out of 20 hours as of the date the petition was drafted.
All right. Do you admit or deny those allegations?
I did turn in my community service hours. I just didn't turn them into the right spot, so I don't know. I mean,
And that is my answer to that issue. So let me tell you what just happened from my perspective. You ready? I've been trying to ask you yes or no questions since you got here. I can't get a yes or no out of you to save your life. I then had Director Matthews read out the allegations, and I asked you if you admitted to the allegations or denied the allegations. So literally, your only options was to admit or deny, and you jump into this. So the idea that they're trying to communicate with you the state's offer and you're not responding tells me exactly what just happened, because I just tried to get you to admit or deny, which are very simple options, yes or no, and I didn't get that out of you either. So I'm just communicating with
sorry,
you
sir.
that their issue that brought you up to this podium is the same issue I'm having right now, and I don't have any trouble seeing that pattern of how we got here.
I'm sorry. I was just not in full understanding of what was.
Okay,
I was just having her read it again, and then.
I will
was
read
going
it again. Did you fail to pay your fines and fees and not take the appropriate steps to get them caught up? Yes or no?
I mean, I did pay the money. I didn't send it to the right spot, I guess. I don't know, but
Okay.
I do have the money to pay it. It's what I'm saying is I don't understand what the confusion is.
So now I'm going to point out for a third time that I asked you a yes or no question, and you wandered off into an answer that was not responsive to my question. So I'm going to take that as a denial. Did you fail to complete your community service work as directed, yes or no?
No, I did not fail to complete my community
Have a
service hours.
Sit down. This is now a fully contested hearing. No, sit at that seat there. Sit at that seat right there. This is now a fully contested hearing. I will hear evidence, and then I will make my own independent decision as to whether or not he has violated his probation. If I determine he has violated his probation, I will take whatever steps I think are appropriate. If I determine he has not, I will return him to regular probation with no changes. We've already established that you have the right to have an attorney, and you're here representing yourself. Director Matthews, fill me in on what's going on.
All right, Judge, this case was sentenced on October 28, 2025. He's been on 122 days, that's approximately 4 months. His first scheduled payment should have been $221, and then the following 3 months after that should have been $171. At this point, he should have paid $734 while he has been on active probation. He has made one payment while being on probation. That payment was made on December the 4th, and it was for $78. Hence the arrearage on the petition drafted before you today. When he was sentenced to do 20 court-ordered community service hours. The deadline for those community service hours was December the 9th, 2025. As of today, we have not received those hours in our office, and that would be approximately 2 months behind at this point.
Talk to me about what options were extended to him other than pulling cash out of his pocket to satisfy the financial obligations.
Well, unfortunately, Judge, due to the court-ordered hours not being completed, the state doesn't allow us to offer him conversions until those hours were completed. So therefore, we couldn't get to a monetary conversion of the court fine on the case. I would have to review the notes to see if there was any communication in regards to being directed to other resources. If you'll give me a moment, I can make.
No, that's all I needed. So that's the answer I was looking for. All right, anything else?
No, sir.
All right, Mr. Allen, you may ask Director Matthews any questions you may have that elicits information that you think is helpful to your defense. And so if you have any questions that you would like to ask her, this is your time to ask her questions. You'll be given a time later to make statements. This is not that time.
All right. If I do have my paperwork stating that I have completed my hours, can I show them to you? Because obviously I'm misunderstanding on where I need to send this stuff.
Okay, that's not a question for Director Matthews. You will be given a chance to make a statement and show me paperwork, and we'll cover that bridge later. But do you have any questions at this time for Director Matthews?
What is it that I need to do to show that I've don't know, I don't understand what
Sure.
y'all trying to get at here.
Okay. All right. I've given him 2 opportunities to ask Director Matthews questions. He has not elected to ask Director Matthews any questions. He has elected to represent himself, and therefore we're going to continue with this hearing. Do you have any other testimony to give, Director Matthews?
Judge, I just reviewed he reported the first time in person and then was moved to online. There's no documentation that he's established that there is a financial need or anything for us to assess him with other options to his case in regards to fees on his case.
Okay. All right. Last chance to ask Director Matthews any questions, if you have any.
What is it that I need to do to satisfy what y'all are asking out of me?
Well, anything that would have been done needed to be done prior to today to cancel this revocation hearing. Once we get to court, there's no way that we can sit here and take in all of your information, because I would need to verify everything, I would need to look into everything, and I'm not in a position to be able to do that. So if you were interested in canceling this court date, that would have been needed to be turned into the office with enough time for us to review it, to make sure that everything was correct and your case was back in compliance.
I'm sorry, I didn't understand that at the time. I thought y'all had received the paperwork that I had sent. I'm sorry y'all didn't. But I did send it. It just didn't go to the right spot, I guess. I have made payments, but my payment was
Okay, this is not
revoked.
the time to make statements. This is the time to ask questions. This is the time to ask questions. So ask a question if you have any questions. You'll be given an opportunity to make a statement. But as I said before, this is not that moment. Questions. Do you have any questions for Director Matthews? Take a deep breath and think if you have any questions and ask them.
Okay, is there any way that I could have a second chance on going over all my paperwork, or?
That's not her call to make, that's mine. And we're in this hearing and we're gonna finish this hearing. So, do you have any other questions for Director Matthews?
No, sir.
All right. State have any additional, anything?
Yes. So in your notes, do you have any indication that there was any questions from the defendant about sending information and whether or not it had been properly received?
No, there's no emails that documented that he has sent us. We have sent him emails. Does not appear to be any response to those emails. And there's no documentation that he's ever called the office since he's been placed on probation for any clarification.
And prior to this hearing date, was the defendant put on notice through emails or through a telephone conversation that that his funds were lacking or that his community service was lacking?
Let's see. Yes.
Pause just really quick. Let's just make sure Terry's happy.
I'm good.
I want to make sure you're happy. Okay. You got what you need?
Yeah.
Okay, continue.
My microphone's so close to his papers that I'll get his papers.
Okay.
So sorry.
That's all right. All right, go ahead.
So there was an email sent on January the 21st that advised him we had received his online report. He had a remaining payment due of $485 and 20 hours of community service by the end of the month. We advised him failure to get his case into compliance by the end of the month. That would have been January, may result in further action being taken on your case.
Thank you. The state doesn't have any other questions.
All right. Any questions? Any additional questions for Director Matthews? Mr. Allen?
Other than I got my paperwork here.
We'll cross that bridge next. Any questions for her?
I know, sir.
Okay. All right. All right. Anything else from the state, Ms. Sexton?
No, Your Honor.
All right. Anything else? All right. Mr. Allen, you have been trying to make a statement this entire time, and I've been saying ask questions, ask questions, ask questions. This is now your opportunity to make a statement. But if you make a statement, you're already under oath. You remember me placing you under oath at the beginning of this hearing?
Mm-hmm.
Yes?
Yes, sir.
All right, which means that you're going to need to speak nice and loud and slow. Miss Terry's going to take it all down, and then Miss Sexton's very likely going to ask you some questions. And you're going to have to answer those questions as long as they're allowed by Georgia law. Do you understand that?
Yes, sir.
All right. If you choose to remain silent, that silence cannot and will not be held against you. Do you wish to testify or remain silent at this time? Or do you have questions for me? I guess I should do three options. Testify, remain silent, or ask me questions about your choice to testify or remain silent.
I guess I need to ask you questions about my paperwork, I guess. I mean,
All right, so is that, no. Do you have the, if you want to present that paperwork, you got to testify. And if you testify, you're going to be cross-examined by Ms. Sexton. Do you understand that?
not really, but I guess, I got my paperwork and everything here. I mean, I don't know what,
I mean,
I'm not really computer literate, so
this isn't about computers. This is about your right to, Miranda rights. You have the right to remain silent.
Yes, sir.
This is me giving you your Miranda rights. You have the right to remain silent. If you remain silent, your silence cannot be held against you.
All right.
If you choose to testify, you will testify to that information and you'll give me those documents and I'll look at them. But Ms. Sexton will then ask you questions and you will be required to answer those questions. Do you understand those rights that I've just explained to you?
Yes, sir.
Okay. Do you wish to testify or remain silent?
I'll remain silent.
Okay, then you can fold those papers up and put them in your pocket because I'm not going to review them. All right. I'm going to find that I've explained Mr. Allen's rights fully to him to remain silent or to testify. He asked me several clarifying questions and that he is making a knowing, voluntary, and intelligent decision to not testify. I will not be holding his silence against him, and I will be making no inferences whatsoever by his silence that is in a negative light to him. Ms. Sexton, do you have any additional, anything additional before we close this whole thing out?
Just a statement,
All right, then we'll do closing. You have the right to go first, last, or both. What do you want to do?
last.
Okay. Mr. Allen, tell me why in the world I should not revoke your entire balance.
I have the money today, and I don't have a job, for one thing. I really don't have a stable place of living, but I have completed my hours of community service.
You can fold that out and put it in your pocket. You elected to remain silent, and you did not present those to me at the hearing, and I will not entertain them at this time.
Okay,
So put those in your pocket and stop trying to show them to me because I'm not going to review them. You decided not to show them to me at the hearing. Okay, now tell me what you want me to know.
like I said, I have the money, and I have completed the hours. I just didn't send whatever to the right spot at the time I needed to spend it or send it, and I was just wondering, is there any kind of way that we can figure this out where I can get the money to the right spot and the paperwork to the right spot? That's all I needed to know. Because other than that, I think I'm doing fairly well. I'm just not knowledgeable enough to send it to the right spot, I guess.
All right. Anything else?
That's it, sir.
The floor is yours.
So the state's position is that Director Matthews presented evidence that he was not in compliance with his probation. There was apparently no evidence or record in her file that the defendant has questioned whether or not his documents and money had been received. Of particular note was a January email that got sent to him that would have allowed him to resolve the issue prior to taking up the court's time today. So it's the state's position that he has failed to comply with the conditions of his probation.
Thank you. All right. The evidence as I've heard it is that Mr. Allen's on probation with the Spalding County State Court in 24 SR 1392. I'll state just for context purposes that this is not the only probation he is currently on. He's also currently on felony probation in 24 R 725A. I only say that because Mr. Allen's statements that he is very confused and doesn't understand what's going on fails a little bit in the light that he's already entered a felony guilty plea upstairs in Superior Court and is currently on active felony probation, which means he is able to interact with some sort of felony probation officer of some type. And I might be mistaken, but that is also Adam Tyler Allen, who has a birth date of 2/6/80. I find that this case here has frankly been very frustrating to interact with. I asked Mr. Allen on several occasions, very standard yes or no questions, was unable to get any sort of acknowledgement. We are having a full-scale hearing, not because Mr. Allen denied it, his allegations, but because I couldn't get an answer out of him one way or the other. And so I had to just assume that he's denying the allegations, and now we've had a full-scale hearing on whether or not he paid his fines and fees or asked for them to be waived, or he turned in his community service work, or he didn't. And I am stunned that we have now wasted 20 minutes dealing with a case that should have taken about 60 seconds, even in a contested manner. I note that he has 243 days remaining, and I note that there is sufficient evidence for me to find by a preponderance of the evidence that Mr. Allen has created a cascade of failures of his own choosing through no fault other than himself, which is that he failed to do his community service work hours and then failed to turn them in properly. I'm not saying he didn't turn them in. I'm just saying he didn't turn them in properly. There's no record of them. I have a funny feeling he sent them in to his felony probation officer, but that's just a suspicion. So by doing that, he blocked himself from being able to convert his fine into community service work, because that can't be done until the 20 hours of court-ordered community service work is done. And then obviously we've spent the whole calendar with Mr. Allen saying he's not certain, he doesn't understand, and unable for me to get any sort of actionable information. If this is how frustrating these interactions are here in this courtroom in its most formal setting when he's on his best behavior, I cannot imagine the difficulty this causes when he's in the sentence enforcement office on a report date. I just do not see any solution for this other than to revoke 120 days and close this case. I don't think Mr. Allen is a candidate for probation. Piper, put cuffs on him.
Are you serious?
I am very serious. And I'm not
I have
discussing
my
this with you.
paperwork and
If you
everything,
want to
man.
keep talking, I can add more days, or you can be quiet and take the 120, because I'm closing your balance. You don't owe anything else. But if you want to continue this discussion, we can continue this discussion. What do you want to do? Good call. Piper, you should take him out of here before he changes his mind and makes a decision he will regret. 120 days revoked, terminate the balance, close it out.
So, can I grab this?
They'll work that out. Piper will get with you. So, all right, you can call your next case.
Judge, the next two cases are gonna be pretrial cases, and I believe you have the paperwork for those please in your box also.
All right. I have Whitner.
Ms. Davis?
I'm not saying I don't have it. I'm just saying I don't have it in my hand. Give me just a second. All right, y'all, you're Miss Whitner?
Yes, sir.
All right, Miss Davis, where are you? Miss Davis, come on up and sit on the front row. I'm gonna do Miss Whitner's plea while we,
Is it all?
maybe? Aha! That's why I can't be trusted with paperwork. That's no one's fault but my own.
I'm like, I know.
Yeah, no, y'all did what you were supposed to do. I did not. So when I picked them up, I clipped the two together. So, okay, Miss Whitner, we're gonna do your plea first, then Miss Davis. You ready? All right, if you will raise your right hand for me, ma'am. Do you solemnly swear or affirm? Will you just pull that door to Miss Finney? Mr. Allen's back there talking up a storm. Okay. Ms. Whitner, let's just start over. Raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, take your hand down. State your full name for me.
Azalea Whitner.
All right, Ms. Whitner, you are here today on 23 SR 943. You are currently participating in our pretrial diversion program, and your sentence enforcement supervisor has filed paperwork alleging that you're out of compliance with that program. Do you understand what you're doing here today?
Yes, sir.
All right, you've had a conference with the solicitor's office, and it looks like you've reached an agreement where you'll come out of the pretrial diversion program and enter a plea to close your case. Is that correct?
Yes, sir.
And is that what you want to do with your case?
Yes, sir.
All right. Now, you have passed up to me, actually, let's go and do this. Do I have your permission to sign this order saying that you've consented to be removed from the pretrial diversion program? Yes?
Yes, sir.
You gotta say yeses. Miss Terry here can't take down a
Yes,
nod.
sir.
She doesn't know what to do with that. So, all right, then I'm gonna find that you're giving me permission to remove you from the pretrial diversions program by consent. I am now holding up this self-represented defendant plea rights waiver. Do you recognize this document?
Yes, sir.
Do you recognize it as the written version of the, nope. Do you recognize your initials next to each of the lines on page 1?
Yes, sir.
Page 2,
Yes, sir.
is that your signature?
Yes, sir.
Did you sign and initial this document after having all the time that you needed to review it?
Yes, sir.
Did you understand everything that's on it?
Yes, sir.
Are there any questions I can answer for you about anything anywhere on this document?
No, sir.
All right. Are you a United States citizen?
Yes, sir.
All right, you just missed a line. I'm gonna initial it. We're gonna keep going. Okay. Ms. Whitner, did you see on here where it says you have the right to have an attorney represent you?
Yes, sir.
And you're here representing yourself. Is that what you want to do?
Yes, sir.
Do you understand that you have the right to a jury trial?
Yes, sir.
And that by entering this plea, there will be no trial. This case will be closed. Is that what you want to do?
Yes, sir.
All right. You are charged with 1 count of simple battery, and that you did here in Spalding County back on 5/2 of 23 commit the offense of simple battery. Let me find your case. There it is. There we go. All right. There we go. Commit the offense of simple battery and that you did have unlawful physical contact with Aheem Butler. And did you do that?
Yes, sir.
Did you also commit the offense of criminal trespass by damaging his iPhone?
Yes, sir.
All right, I find with your admission of guilt across the simple battery charge count 1 and the criminal trespass count 2 that there's enough for me to take your plea. I find that you're knowingly, voluntarily, and intelligently waiving your rights and entering this plea. I reviewed the recommendation and I'll follow it. Any questions about anything before I sentence?
No, sir.
All right. And I will note that you were originally represented by the Public Defender's Office. Is it acceptable to you that you're here today representing yourself?
Yes, sir.
Okay. All right, Ms. Whitner, I find that in 23 SR 943, count 1, simple battery, guilty, 12 months, 870s, you're fine. Count 2, criminal trespass, guilty, 12 months, 870s, you're fine. That's a total of 24 months probation. You may work your fine off with community service work. You will follow the general conditions of probation 1 through 14 on the face of your final disposition, which you've already signed. You will have no alcohol, illegal drugs, or hemp products. Your case may close once 12 months have passed, no violations have occurred, and all conditions have been met, including 20 hours of community service work. You have 30 days from today if you wish to appeal this decision. You have 12 months from today if you wish to use your habeas rights. There was a lot there. Do you have any questions for me about anything before you and I wrap this up?
No, sir.
All right, so you've already met with sentence enforcement, so you're just going to continue meeting with them. All right, do y'all need to talk with her?
We need to get her to sign the pretrial removal.
Okay, so if you'll have a seat in the jury box there, they'll have you sign your paperwork, and then they'll get you out of here pretty quick. All right, Ms. Davis, you can come on up. All right, good morning.
Good morning.
If you'll please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right. Please state your full name for me.
Shawana Davis.
All right. Ms. Davis, you are here today on 23 SR 977, and you're on time for court today, and you are currently participating in our pretrial diversion program. Is that correct?
Yes.
You're here today because your sentence enforcement supervisor has filed paperwork with the court alleging that you're out of compliance with the pretrial diversion program. Do you understand that?
Yes.
You have the right to have an attorney represent you, and you're here representing yourself. Is that what you want to do?
Yes.
And do you understand that there's two phases to this? One is the pretrial diversion program to remove you from it or leave you in it.
Okay.
And it's my understanding that you've reached an agreement where I'm going to remove you by consent from the pretrial diversion program, and then you're going to enter this plea.
Yes.
Is that correct?
Yes.
Is that what you want to do?
Yes.
Okay. All right, Ms. Davis, you, so I have your authority when it's presented to me to sign the document or the order removing you from the pretrial diversion program.
Yes.
All right, I will sign that when it's presented, and you'll sign it as well after the
Okay.
plea. Moving forward into this plea, I am holding up this self-represented defendant plea rights waiver. Do you recognize this document?
Yes.
Do you recognize your initials next to each of the lines on page 1,
Yes.
page 2?
Yes.
And is that your signature?
Yes, it
Did
is.
you sign and initial this document after having all the time that you needed to review it?
Yes.
And did you understand everything that's on it?
Yes.
All right, did you see on here where it says that you have the right to have an attorney represent you?
Yes.
Did you understand that, and you're here today representing yourself, is that what you want to do?
Yes.
Do you understand that you have the right to a jury trial?
Yes.
And that by entering this plea, there will be no trial, this case will be closed? Is that what you want to do?
Yes.
All right, you, do you have any questions for me about anything so far before I pivot to the facts of your case?
No.
All right, let's move forward then into, there we go. Let's move forward into the facts of your case then. You were charged, again, in 23 SR 0977 with one count of theft by receiving, and that was back on May 23rd of 2023. The allegation is that you did receive, there it is, stolen property to which you knew or should have known was stolen back on May 23rd of 2023 here in Spalding County. That being the property of Six Rent-A-Car, SIXT Rent-A-Car, which is a vehicle which you knew or should have known was stolen. Whew, you were knocking on the edge of a felony there. You dodged a bullet on this one. Okay, did you do that?
Yes.
Okay. I'm going to find that with your admission of guilt that there's enough for me to take your plea. I'm going to find that you're knowingly, voluntarily, and intelligently waiving your rights and entering this plea. I've reviewed the recommendation, and I'll follow it. Any questions, ma'am, about anything before I sentence?
No.
All right. Good job dodging that felony, and by doing this plea, you'll protect yourself forever from that
Yeah,
potential
okay.
felony. All right, here we go. Ms. Davis, on 23 SR 977, count 1, theft by receiving, guilty, 12 months, 368 is your fine. You may work your fine off with community service work. You'll follow the general conditions of probation, 1 through 14, on the face of your final disposition. No alcohol, no illegal drugs or hemp products. You'll be tested for those. You will need to show a valid license to sentence enforcement. Your case can close once 6 months have passed, no violations have occurred, and all conditions have been met, including 20 hours of community service work. You have 30 days from today if you wish to appeal this decision, and you have 12 months from today if you want to use your habeas rights.
Okay.
All right, can I answer any questions for you as we wrap this up?
No, sir.
All right, I don't believe you've had a chance to sign the paperwork yet, so I'm happy to have a seat in the jury box.
Okay.
The bailiffs will bring you your sentencing form. Sentence enforcement will bring you the consent. Once you've
Okay.
got all that sorted out, you're free to go.
Thank you.
All right, thank you. If you'll go have a seat in the jury box. All right?
We have Mr. Allen's paperwork if you want to do.
Wonderful. I'd love to do that. Mr. Allen, you can come on up to the podium. Sorry about the trouble. I have a sneaking suspicion that I probably messed it up somewhere. So,
This is a copy, and this is the original that he actually had. And this is my rewrite, because I could actually tell from that.
perfect.
But this is the sign, so I don't know if you need an original to redo it or what you want to do.
Yeah, I want to do this one. So,
Okay.
'cause,
And it mimics this, right?
perfect. So
It
we'll
lets
give
this
these
one-
two back to him, and that way he'll have good records of it.
Okay.
And
I
then I'll
just want to
send
make
it.
sure we're all straight.
Perfect. And there's a right sheet somewhere, but we'll track that down. He signed that somewhere, but we'll have him sign. Hey, Clint, before, he's already done a right sheet, because we've already done all that, but it's missing. So if you'll just get him to sign a new self-represented rights form. Again, he's already filled one out.
I've got one here.
You may have it?
I have one here.
Yeah, he
I
just-
don't have his, but I have one for
Oh,
him to
okay.
sign.
Yeah, let's just give it to him. He'll do it after the plea, because he's already done one. We wouldn't have gotten here without it. So, all right, you ready, Mr. Allen?
Yes, sir.
Raise your right hand for me. You solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right. Mr. Allen, thank you for your patience. Again, I think there's a probably good chance I'm the one who lost the paperwork, just so you know where the fault lies in this moment.
Yes, sir.
But what we've done is, Ms. Sexton has very kindly, or Ms. Haynes has very kindly translated your pink copy over into this one, and we also found a copy of the original, but this way we're just going to do it on a fresh final
sir.
disposition. But you have both the pink copy in your hand and the regular photocopy. And so if it doesn't match this exactly, you let me know, but I just looked at them and they match exactly.
Yes, sir.
But I'm saying if you see a difference, you let me know, okay? All right, now, we have already done your sentence. We did that with Mr. Kendall, who has since withdrawn from your case, but he did leave you with these terms being negotiated, and I will follow the exact terms he negotiated by sentencing you today. Do you understand that?
Yes, sir.
Is that acceptable to you?
Yes, sir.
And is it your wish to remove yourself from the accountability court program?
Yes, sir.
Is that your free and intelligent and voluntary decision?
Yes, sir.
Has anyone forced you to ask in any way whatsoever to remove yourself from the program?
No, sir.
You understand that by removing yourself from the program, you are losing out on the opportunity to get this case dismissed.
Yes, sir.
And instead, I'm about to sentence you, and this case will become part of your permanent record, and you will have a conviction for DUI and hit and run on your criminal history.
Yes, sir.
Is that acceptable to you?
Yes, sir.
And you think that is the better alternative to you than completing the accountability court program? Is that correct?
Yes, sir.
Okay. Well, I'm going to find that we've gone through fully the pros and cons of removing yourself from the accountability court program. I'm going to find that we discussed fully that if you stay in, you get a dismissal. And if you come out, you get a DUI conviction and a hit and run conviction. And that you are freely, voluntarily, and intelligently choosing to remove yourself from the accountability court program and to be sentenced. Is that fair?
Yes, sir.
All right. Anything for me before I sentence?
One question.
Okay.
Is there any way on the 10-day sentence for the jail time? Can I do that on the weekend?
You want to
that
do
possible?
weekends?
Yes, sir.
Yeah, that's reasonable. Hold on.
I
There it
didn't check that box, Ron, I'm sorry, we have to check it.
Yeah, that's okay. I'm going to check it right now. All right, so now what it says is the jail time shall begin within 30 days and shall be served in 48-hour weekly increments.
Yes, sir.
Okay, does that, anything else that you wanted on here?
No, I can work.
Okay. All right, you ready?
Yes, sir.
All right, I'm going to find that there is in the file a transcript of your original Stinson plea, accountability court plea, half a plea, whatever we want to call it. So all I'm doing today is sentencing. So I'm about to read down this sentence. You ready?
Yes, sir.
The sentence of the court, Mr. Allen, is as follows, and Terry, we will need a transcript of this. On 24 SR 1880, from 11/14 of 24, count 1, DUI, guilty, 12 months, $16.95. Count 3, hit and run, guilty, 12 months, $750 is your fine. That's a total of 24 months of probation. All other charges are dismissed. 10 days to serve in the Spalding County Jail. You may work off your fine with community service work. You will follow the general conditions of probation, 1 through 14, on the face of your final disposition. No alcohol, no illegal drugs, no hemp products should be tested for those. You will need to show a valid license if you're able to sentence enforcement. If you're not able, they will give you instructions on how to clear that up.
Yes, sir.
Your jail time of your 10 days will begin within 30 days and we'll have 48, and you'll complete it in 48-hour increments instead of 10 straight days. You will complete 40 hours of community service work, no less than 6 hours per week. You will complete a substance abuse evaluation within 90 days and DUI school within 60 days. I'm marking off the accountability court, and I'm marking that defendant has voluntarily withdrawn from accountability court. And then I'm also going to put that Mike Kendall has withdrawn. Is that correct?
Yes, sir.
All right, you have 30 days from today if you wish to appeal this decision. You have 6 months from today if you want to use your habeas rights. Any questions for me as we wrap this up?
No, sir.
Have y'all met with him or? Okay,
So he has consecutive case, or he has another case, I'm sorry, 24 SR 1880 that he would have completed had he successfully completed the accountability court. That case does not say whether it's consecutive to anything,
yeah,
and I don't know if that one is, do you want this one concurrent, or you?
no, consecutive. So is he currently reporting to y'all on that other case?
It was gonna be the one that we were gonna supervise had he successfully completed the accountability court on that case.
Okay, then I'm gonna mark, what was the other case number?
24 SR 1880.
Okay, then this one needs to be run consecutive to that one. So I wrote 24 SR8. All right, so I did make that change. So you have a case that's already scheduled to start right now. And I'm worried that if I stack them up together, it's gonna be too many items.
Okay.
And so I'm gonna put on here, that this case runs consecutive to that one.
Okay.
But I'm gonna also make it a little bit lighter in that I'm gonna put that this case can terminate, once 12 months have passed, no violations have occurred, and all conditions have been met. So I've stacked this case secondary to the case that's about to start, but I also put it so that you can cut your probation time in half if you do what you're supposed to do.
Yes, sir.
So does that all make sense?
Right.
Is that okay with you?
Yes, sir.
All right, any questions or concerns or objections or anything?
No, sir.
Okay. All right, well, like I said, I moved it to after, but I cut it in half, so good luck to you, Mr. Allen.
Thank you.
If you will, Clint's waving at you there, so you need to fill that out. And then I think Sentence Enforcement needs to meet with you, so just grab a seat in the jury box. As soon as they finish with all your paperwork, you're good to go. Okay. And thank you all.
This is more than that.
Oh, did I think I wrote the wrong case number on it. If so, it's about to get a lot better for him. He's gonna get really excited. Okay. Great job. Where'd he go?
So I don't know if you want to make that.
Yeah, let's clear that up. Mr. Allen, I got great news for you. It turns out there's not two cases, there's just the one. So, but I'm gonna leave it as it is, other than marking it off that it's run consecutive to another case. There isn't another case. This case moving through ended up looking like it was two, and that threw us off. So good news, it's less than you thought it was. There you go, that's a smile, that'll work. Okay, and then I'm marking this off. That's why that's there. All right, anything else? Okay. Good job, Carly. Y'all have a very unenviable task of keeping me organized. I'm so very sorry for what Spalding County voters have put on you. All right, what else you got?
Judge, that's all I got.
All right. All right, so we've taken care of, let's just go through this real quick. Adams was consent, Allen was full-scale hearing, we're done with that. Leonard Allen was sentenced, we're finished with him. Anderson was a consent, Anderson is off. Aston is a warrant. Bailey, we had a hearing. Bass was revoked in full. So she admitted but then denied, and then I revoked. So admitted, but then rejected the offer, and I revoked. She's done. Belsh's was a consent. Britt was off. Davis was a plea. Goodman is a bench warrant lift. Carly has everything she needs on that, so that's off the table. Haynes is a warrant. Hurd was a consent motion. Mr. Carwall is going to send us a proposed order. Johnson's off. King is consent. Knight is consent. Ledbetter's off. Loney, show cause, not here. We're done. Maddox, off. Marshall, off. Slayton, warrant. Stringer, I think, is our next hearing. Whitner, pled. Wilson, off. Wooten, show cause, not here. And then Joyner was bond revoked. All right, did I miss anything or call anything wrong? Okay, Joyner, come on up. I'm sorry, not Joyner. Stringer. Okay, Mr. Stringer, you grab that seat right there.
Yes, sir.
Let me pull your file up. All right. This is the case of the state of Georgia versus Christopher Stringer, 25 SR 0282. Mr. Stringer is seated at the defense table. Ms. Sexton is here representing the state. I know very little, and so Ms. Sexton, I may have you fill me in. I just know this was called for a trial with Judge Essery when I was doing the civil jury trial.
Yes, Your Honor.
And I believe Judge Essery ruled from the bench that Mr. Stringer wanted to release his attorney and represent himself.
Yes, Your Honor.
Anything else that you need to put on the record as far as contextualizing how we got to this moment?
Well, the only thing that I would like to advise the court, since you weren't there, and as Judge Essery was that this appeared on the trial calendar. The state had 2 jury trials, 2 bench trials, and the defendant was represented by the Jukes Law Firm. And prior to the court hearing, I had asked Mr. Charles if we would be able to continue the case because we were already dealing with trials that we were trying to get ready for. And Mr. Charles, who was representing the defendant at the time, agreed to that, knowing full well that the state had not previously asked for any continuance. This would be the first continuance, and just by procedure in this courtroom, each side is always, by matter of procedure, allowed their initial request for a continuance. At that point in time, the defendant stood up and said that he was not agreeing to a continuance. And when the state presented to Judge Essery that we were entitled to a continuance, we hadn't asked for it before, and Mr. Charles consented to that. The defendant then on the spot fired Mr. Charles, and then Judge Essery asked from the bench to perfect the record that Mr. Charles was being released from the case, because at the time there was no motion to withdraw or anything like that. So he was released. And then when Judge Essery agreed to allow the state's continuance, the defendant asked to be heard. And when he asked to be heard, he presented his case that his case should not be continued, and then proceeded to present the court with motions.
Okay. All right, thank you for that. Mr. Stringer, is there any context you want to just put on the record to help me get myself fully up to speed?
Yes, Your Honor. Pretty much what happened, I was talking with with my attorney, and he was saying, you know, I'm gonna ask for a continuance. I was like, well, I can't do a continuance. I have my custody hearing that's coming up. I can't do a continuance. And he was like, I don't care what you have to say. I'm the attorney, so I'm gonna ask for a continuance.
Okay.
And so at that point, I was like, well, if you're gonna do that, then I'm just gonna go ahead and represent myself instead of letting you ask for a continuance. So there was no precursor of any discussion about it prior to that. So I just went ahead and released them so I could go ahead and defend myself.
Okay. And it's your wish to move forward with this case representing yourself, is that correct?
Yes, Your Honor.
All right, well then I'm gonna find that, although I was not there and have not, I don't believe there's a transcript, but Judge Essery did inform me as he left out that he'd had a defendant that he'd had a full Feretta hearing on, which is the letting your attorney go hearing, and that he had found that all of the, that the defendant wished to release Mr. Charles. Defendant had that right. You have a right to represent yourself as much as you have a right to have an attorney. And so you're electing to represent yourself. And so I told him that when I encountered you at the next and he told me that he'd scheduled it for hearings for today. I told him that when I encountered you, I would confirm all of that on the record and that I would place an order in the file saying officially that Mr. Charles was withdrawn from the case and that you wish to represent yourself. Now, I am also obligated at this moment to tell you, Mr. Stringer, that you may still hire a private counsel, although you may not go back to the public defender's office. That's who you had and that's who you get.
Yes, Your Honor.
And they're out. Do you understand that?
Yes, Your Honor.
All right, that was a yes. All right, well then we're good to go on the who's representing him and what do we have. All right, so for today, my goal is to just get my brain wrapped around what do we have, what needs to be done, what can I do today, and what do I need to put off for witnesses and whatnot. So as these are, I believe the majority of what I'm looking at are Mr. Stringer's motions. I would love to hear from you, Mr. Stringer, first. What is it you're expecting to hear or see from me today if I do what you want me to do?
I went ahead and prepared a statement so we could just kind of get to the point. If that's okay.
Go ahead. Just
you-
read nice and slow because Miss Terry's taking down everything we're saying.
Yes, sir. Yes, Your Honor. Your Honor, I request dismissal today based on prejudicial discovery noncompliance and due process concerns. Witness names may have been disclosed, but key underlying evidence was not timely produced for meaningful suppression litigation and cross-examination under OCGA 17-16-4, 17-16-6, as well as 17-16-8. This court authority to impose sanctions and immediate remedies. Under Brady, Giglio, Kyles, and Strickler, material evidence affecting guilt and credibility must be disclosed in time to be used. The prejudice here is present and concrete. A continuance rewards noncompliance and does not cure fairness today. I request dismissal now. If the court declines dismissal, I request exclusion of undisclosed evidence and derivative testimony. If exclusion leaves the state unable to proceed, I request immediate dismissal today.
Okay. All right. So what I just heard mostly was that you would like a dismissal due to procedural discovery violations, which have precluded you from properly preparing a defense in your case. Did I
Yes, Your
sum that up accurately?
Yes, Your Honor.
Okay. And that you are of the opinion that even if the state were to provide that discovery, I think I heard you say that you've already been injured, so to speak, to the point that that cannot be undone. Did I get that part right?
Yes, Your Honor.
Okay. All right. Anything else before I pivot to Ms. Sexton?
Just give me 1 second about the omnibus. Also incorporate the reference. Also incorporate by reference it's might be a little repetitive, but just wanted to make sure I got everything. I also incorporate by reference my filed omnibus pretrial motion and all grounds previously filed for courtroom efficiency. I am not rereading of every paragraph unless the court wants.
No, please don't do that.
Yeah, yeah.
I can read it. So,
But also, just first dismissal for prejudice, discovery, noncompliance, and due process prejudice under FCGA 17-16-4, so 17-16-6 and 17-16-8, as I said before, with Brady, Gillio, Kyles, and Strickler. Second, if dismissal is denied, exclusion of all undisclosed evidence and derivative testimony under OCGA section 17-16-6 and Wong-Sun principles. Third, if exclusion leaves the state unable to prove essential elements, dismissal or directed verdict under Jackson versus Virginia and OCGA section 17-9-1. Fourth, explicit findings of noncompliance, prejudice, and remedy for the record. And I am ready to address the omnibus ground briefly on the court's direction.
all right, thank you. All right, Ms. Sexton, fill me in on this, what this looks like from the state's perspective.
Well, Your Honor, from the state's perspective, these charges are all extremely serious. We have a victim who suffered the material loss of a substantial part of their vehicle when it was allegedly hit by the defendant, who then drove away, and so on and so forth. The state provided documentation to Mr. Jukes, who requested standard discovery requests. The state is currently trying to determine if there's more than one video, which was a question that was on the table. I believe that the arresting officer was Georgia State Patrol, which typically they just have a dash cam and not a body cam, but it is not for lack of us trying to determine whether or not there's additional camera footage. And I believe that the state has done everything that they need to do. The judge should note, the court should note, that the date of this incident was just barely over a year ago. And for a case with so many charges and so many serious charges, and given the backlog that the state court normally has, that this case has progressed rather rapidly through the system. We are about to try this case in April, which is just barely over a year since the incident. The incident was the end of December of 25.
Okay, thank you. Okay, and y'all have served.
I'm sorry, that would be 24, Your Honor.
I translated what you meant. So y'all served all discovery within your possession? Is that correct?
I believe we have, except for we're hunting down the body cam.
Sure. All right, but y'all are not.
And it may not exist, Your Honor.
Sure, y'all are not in possession of it, though?
We are in possession of one dash cam, which I have instructed to download onto a flash drive, and that's the only thing that I'm aware that we have at this time. But we are trying to dig, for our own purposes, we're trying to find it there.
Sure. And have you served these items in your possession on the defendant?
To my knowledge, we have probably served them onto Jukes, but it may not have translated.
All right, that's a great question. Mr. Stringer, have you received a copy of your file from the Jukes Law Firm?
Yes, Your Honor. They told me that the only evidence that they had, and they said they asked them again if they had any more evidence, and they said no. The only one was a dash cam of one cop car showing up after everything was finished.
Okay.
So that would be the dash cam that I was saying I was going to download onto the flash drive, so I don't even.
So they have that, and they gave that to you?
Yes, Your Honor.
Okay, so you're in possession of the video that the state says they possess.
They're in possession of what we're in possession of.
That's what I'm trying to make certain the record is extraordinarily clear, that there's no other items in the state's file that has not been served on the Jukes Law Firm.
To my knowledge, that is correct.
Okay, perfect. And then, all right, so, Mr. Stringer, anything else on the discovery argument before I make a ruling on that?
Just the fact that if, it's just non-compliance to be able to get the discovery when it's asked for it. And if that's all that they have, that absolutely shows nothing. It shows two people standing there.
Well, what it shows is not part of the question today. The question is today, you're alleging discovery violations. Discovery violations is when they say, I've got this amazing document that shows the defendant is totally innocent, but I'm going to drop it into the shredder and it'll never see the light of day. That's a Brady discovery violation. It's things, and some of your stuff doesn't apply, but I got where you were trying to go with it. But my point is that the state is obligated to turn over, frankly, very little in misdemeanor cases. In misdemeanor cases, it's really just copy the accusation, scientific reports, and the witness statement, and really that's about it. They do not have to give a copy of the video. They only have to make it available, but they went ahead and gave a copy to your attorney, who then gave it to you when you fired him. And so you, I'm understanding, have everything the state has. I also am, frankly, very pleased at the speed of this case. This is the speed I dream of in cases such as this. I also know that in these cases, each side gets one free continuance. I've had that as my policy since the very first day I sat in this seat. And so I just wanted you to know that I know you had Judge Essery up here, but had you had me, the outcome would have been the same. I would have said, I'm releasing the public defender's office. You can represent yourself. And I would have granted the state's continuance. And I would have said, we're going to try this in April. Now, we're going to try this in April. Unless you request a continuance, which you're saying you're not, but I'm just letting you know that they've used their one continuance, which means they have to try this case in April, because I would not grant them another continuance subject to some sort of providential cause, act of God kind of moment. What I'm saying makes sense so far?
Are you saying that there is like some sort of crazy evidence that was out there, some video or something that was out there that would show innocence, then, that would be a Brady violation?
Yes, that's the very definition of a Brady violation, is the state is in possession of something that shows you are innocent and they hide it or otherwise don't disclose it. And there's some pretty famous examples of this. If you go do some Google searches, you'll see it where. So I'm saying that I haven't heard anything in this hearing today that tells me there is such a thing that has happened. I haven't heard actually any discovery violations. I've heard that they turned over their file to the public defender's office, who then turned over their file to you. I've heard that the state asked for a continuance to get ready. I haven't actually heard any violations that have occurred. So I'm just acknowledging to you that I'm still waiting for someone to tell me where something went wrong.
Yeah, well, I'm just asking, would that get it dismissed today if I had proof that they were hiding evidence?
Yeah, what do you got?
It would?
You have proof that they're hiding evidence?
Yeah.
Okay, you have proof that Miss Sexton over there has evidence in her possession that she is intentionally hiding from the court.
Yes, Your Honor.
To make you guilty.
Yes, Your Honor.
I don't want to see it. I want you to tell me what it is. Tell me what is in your possession that shows that Miss Sexton, an officer of this court, is intentionally violating the law by refusing to provide evidence that's exculpatory. I want you to say, evidence item number 1 is.
Yes, sir. I'm just trying to get to the part where I wrote it down. I wasn't going to offer it today. I'm offering it to show material and materiality.
No, don't read that to me. Don't read me anything.
Okay.
I'm having a conversation with you, and I'm asking you a very direct question. I want you to look me in the eyes, and I want you to tell me the answer to my question.
Yes, Your Honor.
What does she have in her possession, in their file, that is being hidden from you that proves that you are innocent? You said you have these things, and I'm now asking you for the third time, because this is like a really important moment.
Yes, Your Honor.
What is in their possession that you're saying you know about that proves that you're innocent?
Body cam video of civil rights violation, Your Honor.
So you're saying they have body cameras that they are not giving to you,
Yes, Your Honor.
and they are intentionally withholding those items,
Yes, Your Honor.
and they're lying to me and telling me that they don't have them.
When I asked my attorney if they had any more evidence, they
I'm
said
asking
no.
you,
Yes.
are
Yes, Your
you
Honor.
telling me that Ms. Sexton is lying to the court by saying she does not have these items, and you're saying you have proof that she has these items in her possession.
Yes, Your Honor.
What is that proof that you have that shows that these are in her possession?
The actual video, Your Honor.
Okay, well then let's back it up one step then. What is this actual video from? Who is it? Whose dashboard or body camera video is it?
It's the body cam of the arresting officers, Your Honor.
And you're saying that it's in their possession and they're hiding it?
Yes, Your Honor.
Great. You have the subpoena power of the court. They are not the only ones who would have it. You may subpoena it from the other, wherever it may be. But as of this moment, you telling me that you think something exists that they're saying they don't have is not enough for me to find any sort of discovery violations.
Your Honor, I have it with me.
So, well, have you?
Well, that's news to us, because
Yeah.
the only thing that I can represent to the court is that as of last night, as of 8 o'clock last night, I was looking through files to try to find anything other than a dash cam. And I had Georgia State Patrol, who has dash cam and not body cam. Quite frankly, I'm hoping they have body cam because of the incident report, which will help me, and I don't have it. And,
Yeah.
And we are going to continue to look and see if there is additional footage. If there is footage out there, I am unaware of it, but have been requesting it.
Right. Okay.
So it's not in my possession that would exonerate him, that I am withholding.
And as soon as if you do become in possession of a body camera, you will turn it over to him promptly.
Absolutely.
All right. And you've given them your contact information, email address, all that kind of thing?
If you want my information, you're more than welcome to, but
I'll give him a
it's,
notepad or something. He can write all of his contact information down. All right. I'm still not hearing any sort of violation, but what I'm going to do is, all right, anything else? You said the body camera. Anything else that you're saying they're hiding from you?
but Your Honor, you were saying yourself that if I had video footage that they were hiding, that it would be a Brady violation. We get it
She's
dismissed.
just said they're trying to find it. They're trying to get it. So her saying she's trying to find it and get it, and you saying they're hiding it, do not exist in the same world to me. Okay? You need something to show. You need the video, and you need to show me that that video has been intentionally hidden from you and kept from you. I've got her saying they're diligently trying to find it. I still have 6 weeks until this trial comes up. And frankly, they only have to serve it on you 10 days before trial. So I get your indignation, but I'm not feeling it at all. I'm seeing the state trying to get discovery and serve it on you, and somehow you got a copy of a document that you haven't served on them that you're now trying to beat them over the head with, and I'm not feeling it. I'm going to tell you right now, I'm not feeling any of this. I haven't heard anything wrong at this moment to justify any of these motions.
And
So-
quite frankly, on the record, the state is asking, if he's got a copy of video footage that has something to do with this accident, I would like a copy of it because I don't currently have it.
All right, you're under no obligation to serve it. Do you want to give them a copy of it, or do you want to keep it yourself and keep it?
That's perfectly fine. Yeah, I'll give it to
Great.
you.
He has elected to engage in reciprocal discovery. Do you agree to
Right.
engage in reciprocal discovery on all items that you have in your possession, or do you wish to not engage in reciprocal discovery? Just a yes or no. Do you want to give them what's in your possession, or do you want to keep it hidden in your file? It is your decision. I don't have a preference.
Is it going to be shown today, Your Honor?
No. This is preparing for your trial. This is not an evidentiary hearing. This is y'all telling me what's going on with this case so that I can line it up for a jury. That's all we're doing today. So, do you want to give them copies of these things you say you have, or do you want to keep them in your file? I don't care. You just need to make a decision. What do you want to do?
I don't have it with me at the moment. I mean, I have it with me at the moment, but I don't have any way to kind of transfer it at the moment.
I'm asking you if you want to engage in reciprocal discovery. So are you agreeing to give it to them, or are you agreeing not to? Because I asked you if you're going to give it to them or not, and you're telling me you can't do it at this moment, but that's not my question. My question is, are you willing to give the state the items in your possession that you say prove Brady violations or not? Your answer is simply your decision. I don't have a preference, but I need to know your decision so that I can make my decision.
Yes, sir.
What's your answer to that question? Are you going to give them the items in your possession that you think just showed Brady discovery violations or not? Yes or no?
Um, I mean, would it support immediate sanctions?
It's a yes or no. I've asked you a yes or no question, and you're responding with a question to me, and that is not at all what you should be doing at this moment. As you can tell, I'm already a little frustrated because we've just spent 20 minutes doing what I think has been a complete waste of time. I haven't heard a single violation. I haven't heard anything that even hints at a violation. And I'm trying to bring this to a resolution to get you to your constitutional jury trial so that you can have a jury of Spalding County people sitting over there to decide your case. Okay? And I feel like every time I get it almost there, you're shucking and jiving and I'm losing this. So I'm going to ask you the question again, and do not respond with a question to me. You are under no obligation to turn over whatever stuff you got in that pile right there to them. Do you understand that?
Yes, Your Honor.
Do you want to turn it over to them so that we can explore these Brady violations, or do you want to keep that stuff secret in your file and then just surprise them with it at trial? You have that right if you choose that.
Yes, Your Honor. I will go ahead and turn it over to him
Great.
after all the discovery.
We're done. Turn over your stuff. Ms. Sexton, if you find anything anywhere else, please make certain that you turn it over to him within at least 10 days before trial so that he has time to review it and make certain that it's ready. If it turns out by some insane set of circumstances that there is, I'm just going to say it out loud because it is my job, that Ms. Sexton is intentionally hiding evidence in her file that she is doing, I will address it at that time when we call this case for trial. But again, I haven't even heard the barest mention of it. All I've heard so far, Mr. Stringer, is that you got a copy of the video before she did. I just want you to understand what I'm seeing from this seat, that you got a copy of the video before she did, and now you're trying to use it as a hammer to beat them over and win your case. I get it. I would do the same thing if I was in your seat.
Not at all, Your Honor.
But that is, no, I'm telling you what I'm seeing. Your opinion of my opinion is irrelevant to me. Your opinion of my opinion is irrelevant to me. I'm telling you what I'm seeing so that you understand why I'm frustrated. Because this should have been a 3-second conversation. Hey, Miss Sexton, I got a copy of the dashboard of the body cam video. Would you like a copy? Hey, Miss Sexton, I got a copy of it, and I'm not giving it to you, but I'm telling you there's a copy of a body camera video, and you need to know it. Like, that's this whole issue and how it could be sorted out in 5 seconds. Okay, do you have anything else for us to discuss before we wrap this up?
Yes, Your Honor. Just one last thing. I'll just, if anything, I'll leave it at that for now.
Okay, good call. All right, this hearing is adjourned. We will return to this at calendar call, which is currently scheduled for
3:31, I believe, Your Honor.
3:31. You've already signed a reset notice for that. Is that correct, Mr. Stringer?
I believe I've received one. I think I've signed it as well.
Didn't you sign a reset notice in the courtroom with Judge Essery?
I believe so.
Is that right? Okay. Do you need another copy of it? You're hedging, and I'm trying
No,
to
I
figure
have
out why
it.
you're
I
hedging.
have it at home, Your Honor. I wasn't sure if I signed it or not, but I have it at home.
I tell you what, you're going to have to stay until we give you a copy because your answers are making me profoundly uncomfortable. So you're going to need to stay until we print a copy, and we'll give you a copy before you go. All right, I will see you back here on 3/31 at 9 a.m. sharp. Your jury trial is the entire week of May 13th at 9 a.m. each day until your case is closed.
Your Honor,
Yes.
is it May or is it April?
I'm sorry, April. So April 13th, 2026, the week of April 13th, 2026 at 9 a.m. each day until your case is closed. Mr. Stringer, I understand that you want items that are being provided to you, and the state is under an obligation to give you certain items. But I need you to hear me say they are under no obligation to give you a copy of their video. How do I know that? Because I was a defense attorney for many years, and it used to drive me insane that other offices would say, you can come to our office and watch our video, but we're not giving you a copy of it. So I'm just telling you that I get your frustration, but this is the system and how it works. And we aren't perfect, and things aren't necessarily as they are where we want them to be, but we get it right at the end of the day. Okay, you officially have a copy of your reset notice. All right, I'm adjourning this hearing. It's 12:15. You need to make certain that you give them a copy of this item you've said that you would. I've already said to you that you're under no obligation to do so, but you've elected to do so, and that's your decision. Anything else, Mr. Stringer, before we adjourn?
That's it, Your Honor.
Anything else, Ms. Sexton, before we adjourn?
No, Your Honor.
Mr. Stringer, I will see you back here on 3/31 at 9 a.m. You can continue to represent yourself, or you can hire an attorney. I don't have any preference on that, but the public defender's office is closed to you.
Yes, Your Honor.
All right, thank you so much. You're free to go.
Thank you. Oh, I did, yeah. I'll give her the rest of the information.
Okay, what else? Anything else from you? Anything else, Ms. Sexton?
No, Your Honor.
Oh, yeah, the guy, I forgot what you're here for. You were here to talk to me, sir? Yeah, come on up. I don't remember what you're here for. I just remember I said, have him walk in, and that's all I remember. So, you are? Okay, I just remember just saying, just have him walk in. We'll put it on the record. All right, tell me, before you tell me who you are, tell me what case you're here for.
Robert Parlier, Parlier.
All right, let me see if I,
24 SR
Thank you.
1885.
okay, 24 SR 1885. Okay.
I should have given you a card.
There it is. Okay. Robert Parlier, Parlier. Looks like he has an outstanding probation warrant. Oh, he's currently incarcerated? Okay, so he's currently incarcerated. All right, now that I have the case and we've given Terry enough information to be able to mark her calendar and whatnot.
Yes, sir.
Raise your right hand for me. Do you solemnly swear or affirm that any testimony you may give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
I do, Your Honor.
All right, take your hand down, state your full name for me.
Jonathan McElhaney, that's MC,
Gotcha. I'll just put you as.
ELHANEY.
Okay, and tell me, so obviously you're not on the calendar.
No, sir.
Again, I just said, I don't know, just have him walk in on a Thursday. So you're here now. What is it you're looking for from me?
Judge, I just wanted to, I feel like Ms. Fennessy, as well as Your Honor, has received a lot of inaccurate information. And I just want to give y'all another side to what you've heard so far in this case.
All right, so I have actually heard nothing other than just enough to issue the warrant.
Yes, sir.
And it looks like there was a previous consent order.
Run it down for you.
I was about to say, let me pivot to Director Matthews and
Yes,
get a little
sir.
more context, because I don't plan on having a full contested hearing. I just, like I said, somebody wanted to talk, and I was like, I'd just bring him in on Thursday. Go
All
ahead.
right, I'm just gonna try to go through it quickly. August 27, 2025, he tested positive for meth. When he went to be arrested on September 25th, 2025, when they were searching him, Deputy Piper and Deputy Cersei located false urine on him in my office. At that point, I should have asked the court to revoke that case, but I chose to give him a second chance. He chose to sign a consent offer that, and we're gonna be specific on this verbiage, case is revoked in full, suspended upon entering an approved treatment location within 60 days of release for a minimum of 12 months. If defendant leaves or is discharged for any reason, the defendant needs to turn himself into the Spalding County Jail to serve the remaining time. Once treatment is complete, the case may be reviewed for modification. He entered treatment at Teen Challenge on or about October 27th, 2025. He left on January 27th, 2026. The letter that we received from Teen Challenge states that he voluntarily left the program to attend another local program. The court issued a warrant on or about February the 3rd of 2026. We emailed the defendant that he needed to report to our office on February the 3rd. We also attempted to call him on February the 3rd, as he did not turn himself into the jail immediately. He came into our office on or about February 19th, and that's when he was arrested and taken into custody. I met with him at the jail yesterday with a consent offer. He has 511 days. Again, the case is already revoked in full. I offered him a consent for 365 days, and he refused that consent.
Okay. I mean, I don't see a hearing for me because it's already done.
That's correct, Judge. That's why I wanted you to have that information.
And that makes sense of why you're walking in. Okay. It's McElwaney, right?
Yes, sir, it is.
Mr. McElwaney, I don't have any intentions of relitigating this issue, but if you want to give me an elevator
I do, Judge.
length pitch as to what you want me to know, I would love to hear what you have to say, but I just want to make certain it's very clear, this is an elevator length pitch.
Yes, sir.
Off
And thank
you
you, thank you, Judge. I run New Beginnings Recovery Homes for Men in Dublin. Teen Challenge is the program that he was sent to through probation enforcement. Mr. Parlier was speaking with his community health counselor. They had issued him, community mental health, they gave him medication while he was at Teen Challenge. Teen Challenge told him he did not need to take his medicine, he needed to pray, that praying would correct it. Mr. Parlier questioned the homosexual activities going on at Teen Challenge that was supposed to be a Christian-based program. And they didn't like his questioning the program. So he talked to his caseworker, who's also here with me from Community Mental Health today, and they were looking for him another program to go to, which was not mine. I became involved on 1/27 of 26 when Teen Challenge called me and told me that they was making him leave because he was telling the counselor about the things going on at Teen Challenge. There's also a state investigation going on about the homosexual stuff going on between the staff and the male residents there. So just, Your Honor, just me stating, I wouldn't stay there for one day. That he stayed for 6 months was amazing to me. Teen Challenge requested me take him. He didn't have an option to leave. They called me and said he has to go. I sent a driver in a van. I picked him up from Teen Challenge, and I notified Ms. Fennessy. My office notified Ms. Fennessy the following week. Ms. Fennessy said she'd get it worked out. A few days later, Ms. Fennessy advised me that you issued a warrant and gave me a date for me to bring him to turn him in. He wasn't just arrested off the street. I drove him from Dublin to the office. We knew he was going to be taken in custody because of an email Ms. Fennessy sent me. The deputy's statement earlier, he left one program, Judge, not two. Just one is what he done. And I just wanted you to be up to date. I'm saying nothing here that you couldn't verify with a phone call to Dublin, Georgia State Probation, DCS. There's a lot of moving parts about that program. I've had state investigators that has interviewed other male residents in my program that came to my place from Teen Challenge. That's how I'm privy to know about the things that are going on there. So I believe in this young man. And like I told Ms. Fennessy, I would pay his fines out of my own pocket if given the opportunity. From the time he came to my program to the time I drove him to Ms. Fennessy's office, that young man has done nothing but the right thing. That's why I'm standing here today.
Okay. All right. And I understand what you're asking, that he's currently incarcerated, did not sign the new one, and you would like him to be released back into your program. Is that correct?
A 24-month program, Judge. He gave up a 12-month program to come in a 24-month program.
Okay.
Yes, sir. That's
All
what I'm
right.
asking.
Thank you for bringing this to my attention. I'll take a look at it.
Thank you, Judge.
Thank you. All right. Anything else? You're good to go.
Thank you. Have a good day.
And I printed a copy of the consent order, the original consent order. Do you have a copy of the original consent order?
I don't, Your Honor.
Okay, I just printed a copy for you. Just stick around for just a second. We'll get you a copy.
Yes, sir.
I think you need to see it. So, okay, anything else before we adjourn? All right, then, issue the warrants, forfeit the cash bonds. It's 12:24. Sentence enforcement has to go start meeting people in 26 minutes. And that's it. Court's adjourned.